afternoon, and
Greetings.
welcome to your Construction Safety Association of Manitoba's 2025 Safety and Health Week virtual webinar series. Safety and Health Week is an annual occupational health and safety celebration. Safety and Health Week focuses on the importance of preventing injury and illness in the workplace and raises understanding and awareness of safety and health issues. My name is Megan Story, and I am the Training and Development Manager of the Construction Safety Association of Manitoba. And we are proud to be recognized as your premier and trusted source for safety and health information, resources, training, and core certification. Today's virtual webinar is an example of how we are striving to provide you with practical and relevant information to help with accident prevention in your workplace. For those of you who know CSAM, quite simply, our answer is yes. How can we help? We will have the answers to your safety questions, or we will find the answer with the help of our qualified resources and partners in safety and health. Today, I am pleased to introduce Marty Danielson. In today's webinar, Marty will discuss what happens when a stop work order or improvement order is issued on your site, including a clear breakdown of these orders, including definitions, when they're typically issued, and practical guidance on how to respond. Marty will also walk through the appeal process and explain how to challenge or request a review of an order if needed. Please note that this webinar is being recorded and a copy of Marty's presentation will be made available. So at this point, Marty, I will pass on the host privileges to you, and you will be able to share your screen.
Good afternoon, everybody. Thank you very much for having me today. I see there's 44 of us. So before we get into it, I think there's about 11 or 12 slides, and it depends on the group if we get through the slides and at what pace. Sometimes I can have 8 slides in an hour and a half. I can't get through them when it's face-to-face because there's so many questions, which I love. So I encourage questions because questions is how we all learn. But sometimes on virtual, sometimes people aren't asking too many questions and we can get through the slides pretty fast. So I really don't know. I'm banking on this taking an hour, so I'm hoping we can fill that hour. And I'm hoping you guys can leave some information that you're hoping to gain here today. So thanks very much for inviting me. I enjoy doing these things here. Okay, so Megan, how do I hide this? Right there? There you go. Awesome. Okay, so when I build these presentations, just quickly, typically I'm building them for a large in-person audience, and there's a screen that's 50 feet away and everyone's trying to read it. So I use large font, and forgetting that today was, or not thinking about today being virtual, I made it with these horkin' big letters. So I apologize for the size of the font, but so just bear with me. So in short, today, what we're gonna be talking about is kind of an overview of the officer's powers, what acts and laws they get those powers from, what the powers say that they can do in the act, some of their enforcement tools that they have to deal with compliance issues, and what you folks can do if you ever receive one of those things. Okay, so let's jump right into it. So workplace safety and health, a lot of people think we enforce just the act and the regulations, but it's actually larger. So it's obviously if you ever seen the big hard copy of the book of the act and regulations, it's about 340 pages. The first 50 pages or so are the act. The other 300-ish pages are the regulations. But then an entirely separate regulation is geared for the mining industry, which is the operation of the mines regulation. And then there's the administrative penalty regulation. That's a regulation that what is this here? So the administrative penalty regulation. So that is kind of shows the table of the fine. Like when an administrative penalty is issued, the workplace safety and health director is the one that issues those penalties, and she doesn't just pick what the fine is arbitrarily. There's an actual schedule that tells her what fine is applicable to which infraction, first offense, second offense, third offense type thing. Okay. So safety health officers have many legal authorities as stipulated in the Workplace Safety and Health Act under powers of officers. A summary of their powers are: a safety health officer has the ability to enforce the Workplace Safety and Health Act and associated regulations. At any reasonable time, they can enter workplaces without a warrant, conduct investigations, take measurements and samples, test equipment, and require demonstrations of machinery use. They can also inspect documents, interview individuals, and and detain items as evidence. Additionally, they can direct that workplace remain undisturbed for investigations and perform other actions authorized by the minister. So essentially, if there is something going on in a workplace where we feel that we need to get in there, the act gives the officers the powers to enter the workplace. Does that happen very often? Not very often. Typically, when we show up to do an inspection at a workplace, there is an issue and we're allowed to come in. But there has been times where employers say that we're just not coming in, and they will not let us in. In those cases, which doesn't happen very often, maybe once or twice a year, we'll get the local police. First of all, we'll get them to call their counsel and explain their thinking to their counsel, and see if their counsel can kind of set them straight. If not, then we'll go with the local police and we'll get into that workplace. So what enforcement tools do officers have or use when they have a contravention that they're trying to resolve, I guess you could say? So when there's a safety and health officer's an opinion that a person is contravening any provision of this act or regulations. Now, this is a big one here, okay? So I'll start over. Just pay attention to this one if you weren't by chance. So a safety and health officer is in the opinion that a person is contravening any provision of the act or regulations or has contravened any provision of the act or regulations. In circumstances which make it likely that the contravention will continue or be repeated. So what that means is we have good information that something happened at a workplace that was unsafe and against the act or regulations. But when we get there, it's not happening at the time because we know it did happen. And if the officer feels it's likely to continue to happen, the officer can issue an improvement order without even seeing it in front of them if they have reasonable cause to believe it did happen and it's going to be repeated or continued. So essentially you could get an order for something that isn't going on at that time. Okay. So the officer may make an improvement order against that person, requiring that person to remedy the contravention within such a period of time that would be specified in the order, and stating the reasons for making the order and requiring the person to maintain compliance with an improvement order. So when the word person is in there, when you look at the definition of person in the act, it expands to like an employer. So a person can be in a place of employment. So, for ease, you could take the word person and put employer in there, or you could leave person in. So essentially, if an officer goes to a workplace and they see something, if any of you have heard me speak before, let me just roll back a little bit here. If any of you have heard me or seen me speak before, you would have heard me give this example. So our officers are trained to use their discretion. So we train them on the act and regulation and how it's used. But things can be interpreted differently depending on what they're seeing, right? Like the act or the reg might be written in a certain way, but that could be that scenario can change 100 times over depending on the employer. So when we see something, then the officer has to use their discretion to determine how they're going to deal with it. So if a safety and health officer was driving along a little road in Manitoba, and this is the exact example I use all the time. When we teach new officers, I use this example. If they're driving along a rural road in Manitoba and they come across, say, a small construction site, 4 or 5 workers, the officer is the only car that came along or across these workers, and the officer found that they weren't wearing appropriate high vis. The officer is going to use their risk assessment training they've been given, and so they might see that there's a contravention here. These are construction workers working on the side of the road, and they have high vis on them, but not the proper high vis. The hazard is the workers getting hit by a car. So it's a pretty big hazard, but the risk is really low because there's no cars around. So the officer might not even issue any orders there, or else they might say, you know what, given that the risk is low, I'm going to give you an improvement order and you have until the end of the day tomorrow to comply with this order. So to tell me what you're going to do to fix it. They're going to give them a bit of time with it. Maybe they have to buy more PPE or whatever the situation is. It's going to give the employer a bit of time to remedy that situation. So they can essentially keep doing what they're doing, but they got to stop it by X amount of time. So that's how an improvement order works. It's the officer going to lay out the part of the legislation. Here's the part of the legislation that you're in non-compliance of. And here's kind of what you have to do to remedy the situation. And here's the date you have to remedy it by. Okay. So the employer would then have to remedy that situation by that given time. Now, it could be that same day. We had one of our on-call officers issue orders on Sunday that were due, or 2 days ago on Sunday on the 4th. And the orders were due yesterday. So she gave a 1-day compliance in that case, which is When you get a 1-day compliance date, you're about as close to a stop work order as you can get. Okay, so in this situation here, they might not get an order, and maybe they'll get a week or something. Now, if you take that exact same crew and you move them to Portage-Germain on Monday morning, the hazard is them getting hit by a car, but the risk has gone through the roof now because there's tons of cars and it's everywhere. So that same officer and that same crew with that same hazard with a very different risk might now issue a stop work order and say, you guys aren't touching anything. Okay, so we're just going to move forward a little bit here. So if the officer sees something, let's say it's a contravention on, I don't know, let's just say it's a machine guard on a saw that they feel isn't, or they're told that it isn't used very often, and it's maybe longer pieces of material in the worker's hands aren't near the exposed edge as often, and the officer is comfortable with issuing an improvement order. The legislation gives the officer the ability to issue a stop work warning. So where the officer believes that a contravention involves or is likely to involve a serious risk to the safety and health of a person in or about the workplace, they may, in the improvement order, so in the improvement order itself, it'll say stop work warning. Specify that if the contravention is not remedied within a period mentioned therein, a stop work order may be issued. So what that can say is, I'm comfortable with you folks continuing the way you're working for another 2 days or 5 days, whatever you've been given on the improvement order. But after that period of time, I'm not comfortable with the exposure to the risk anymore. Because I think more than 5 days being exposed to this risk, now we're rolling the dice and I think we're more likely to get an injury. So I'm going to stop work warn you. If you are not in compliance with this improvement order by that date, I'm then going to move this into a stop work order. So but the officer has to, on the order, check off, make it known that there's a stop work warning in effect on this one. Okay. So, and it says that right in here, they may in the improvement order specify that if the contravention is not remedied within the period mentioned, a stop work order. So the officer has to specify it. Okay. Is there any questions so far? So I don't know what you guys see, if you can see me or not, but I'm just looking at a PowerPoint presentation, and I've often wondered what it would be like to be like a radio personality when you're locked in a room, just talking, trying to fill the space with words. And I kind of feel like that a little bit right now. So
Marty,
Hey,
there's
Marty.
one question here in the chat.
Yeah.
It says, is there a requirement to state the basis of entering a workplace?
That's
No.
going back to when you said the officer has the right to enter a workplace.
Yeah, it's at a reasonable time, any reasonable time.
So I'm just wondering, if I'm the project manager and the officer shows up and wants to enter the site, would they have to specify this is just a drive-by inspection, or we had a report, or would they have to reveal anything?
No, like if there was an incident, obviously we're going to say we're there for an incident. If there's a work refusal or if there's a reprisal, we're going to say, hey, this is why we're here. But when we've had a tip or a complaint about a workplace, we typically don't say that we're there for a tip or a complaint. We say we're there for a general inspection, simply because we don't want a target being put on someone's back. And we're certainly not there to make things worse for anybody. We're just there to see if this is a legitimate concern. And if so, we'll deal with it appropriately. Sometimes we go to these tips or complaints, and no orders at all are issued. Because when we get there, we found that, it's not reasonable what was brought forward, and it's not illegal. But yeah, when we get there, we don't have to say why we're there. If we're there for a specific thing, like I said, reprisal, stop work order, an incident, 100%. But if it's just a general inspection, no.
There's another question in the chat by someone else.
Okay.
Yes, thanks, Ed. So the next question is, are officers exempt from completing orientations upon arrival to shops or field sites?
Like, we typically do them, but if there's something going on where we feel that we just need to get in there and take a look at something before that stops, while we're like, if we were told there's something significant going on at this workplace and it sounds pretty hazardous, we need to just get in there and go deal with that. Because sometimes an orientation can take an hour or so. Lots of times when a big project fires up, like I remember the Human Rights Museum, we had quite a few officers go through the orientation. And then once they had it, they would just, when they would go do their inspection, they were able just to walk right in. And they were in the first place. We don't want to not go along. We definitely don't want to not go along with something on the safety program. But if we're going to be in and out and deal with something, then in that case, they may not do it. It's not a requirement through the Act or regulations, and we have the ability to do it, to just walk in. But like I said, typically we'll go along with that stuff for sure.
Okay, one more question, Marty, just to build on the last one. Do officers need confined space permitting for a site?
If they're going to go in so our officers won't go in a confined space. Does that make sense? Does that answer your question? All of our officers have been through confined space training, even myself. I used to be an officer out in the field. Through training, like when a safety health officer starts with the province, it's kind of like the police. So when you apply with the police, you go into the academy, right? And you go there for however long it is until they eventually get released and they graduate and they get released in the field. I'm not by any means saying that we're police, but it's kind of similar. When we hire a group of officers, we have, I think, about 8 or 10 of them right now that are they're just finishing their training next week. They've been in training since December, and they come in pretty much every day and they go into a classroom environment. Sometimes we bring in people from the outside to train them. Typically, it's our own officers that are training them. And then throughout that time, there's some field chatting when they're going out and they're going to see the stuff that they were just taught that week. So it's a 3-4 month process, and eventually they're out into the field. Well, part of that stuff is training about working at heights. It's asbestos awareness training. It is confined space training. But when we go to a work site, if there is something like an incident that's happened in confined space or an excavation or something like that, we're not ourselves going in there. We're letting the fire folks that do that for a living, they're going to be going in there. And then in a general inspection, we won't go into a confined space typically, unless there's something going on, and that would be a discussion kind of behind the scenes probably first. Does that answer your question?
All the questions so far.
Okay, good questions. So now this gets into stop work orders. So where a safety and health officer is of the opinion that activities that involve or are likely to involve an imminent risk to serious physical or health injury are being carried on or about to be carried on in a workplace, or where a contravention specified in an improvement order was not remedied and was given and a warning was given, the officer may issue a stop work order. So the stop work order often, most of the times, is not for a workplace. It's for a specific task at a workplace. So let's say a stop work order was given to an ABC roofing in Manitoba because workers were observed working above 10 feet without fall protection. The order would be given for working at height. So now in that case there, that would kind of grind that employer to a halt, but that's not saying that they can't do other work on the ground or what. Okay, so the employer hasn't been stopped, the site hasn't been stopped, working at heights has been stopped. So, like I said, in a roofing company example, you've kind of ground the whole place to a halt. But if you're in a large manufacturer and we're issuing a stop work order to say a break or a shear or something like that, it's just that one break or just that one shear or maybe just that one forklift that has been stop worked, and everything else around it can continue to work. It's just that particular task typically or machine has been stopped. We've been to multiple fatalities where obviously they're horrendous and nobody wants to be part of that, but they clearly have happened quite, many times in Manitoba. But the work around that, like the actual where the incident was and that immediate work has all stopped, but there's nothing preventing other type of work from legally continuing. Now, people, typically it does stop, right? Because people are devastated and the employer kind of shuts down the operation. But there's nothing requiring it to stop. So the stop work order is usually just for the task at hand. Questions?
Nope, you're in the clear.
Okay, so this one here, we don't issue a pile. Like every year they get issued, just not every week or every month type thing. Okay, so if essentially, so this is called a multi-site stop work order or provincial-wide stop work order. There's different jargon for them. So where a safety health officer is an opinion that activities that involve or are likely to involve an imminent risk of serious physical or health injury are being carried on or about to be carried on by workers of the same employer at more than one workplace, the officer may make a stop work at at any of the employer's workplaces. So typically where we see this is in the construction scenario I'll use. Let's say picture demo, picture excavations. So demo, I'm thinking, asbestos specifically. So excavations, demo, asbestos, working at heights. So if we've done an inspection at an employer and we catch them doing, whatever it is that they shouldn't be doing, and a stop work order is issued, and maybe a week, 2 weeks later, we go to a different one of their sites and we see something similar going on, and maybe there's a third, but there definitely wouldn't have to be. If we see the same activities going on with different crews throughout Manitoba, we have the ability to tell that employer you're to cease operations at all of your sites or at some of your sites until you provided to us a plan that would demonstrate that this is not likely to continue going on in Manitoba. Like I said, it doesn't happen that often. Maybe employers think it happens quite often, but we do 6,000 inspections a year and issue 12,000 orders. So in comparison to those, it's not that often, but it happens enough that we have to use it. So that's a big one now, because it might be an excavation company saying that you're not allowed to dig anymore, or a demo company saying you're not allowed to demo, or a roofing company saying you can't work at heights. So that grounds that business to a halt, right? Until they have demonstrated to us how they are going to prevent the activities we're seeing from continuing moving forward. So this is a big one here. This is because we think that people's lives are at risk. And obviously this can cost a lot of money to an employer. Thoughts, comments? Nothing? Okay. While a stop work order is in effect, any worker who is directly affected by the order is entitled to the same wages and benefits that he or she would have received had the stop work order been issued. Not been issued. And the employer may reassign the worker to alternate work. So if it is workers on a roof and we have stop worked them from working at heights, they have to continue to get paid, but the employer can find them alternate work that isn't in line with the stop work order. So there may be bundles of shingles that need to be moved from the trailer to the foundation area of the house. Maybe there's a bunch of shingles on the ground that need to be picked up. Whatever it is, they can do all that type of stuff, but they can't work at heights. If there isn't work available, the employer can apply to the director and to say, hey, listen, I don't have other work, and the director may make a decision to say, okay, we're gonna halt the wages being paid because it's not reasonable in this case. Or the director may say, no, this is a cost of or the ramifications of working in a dangerous manner and receiving a stop work order. The workers should have been working in this manner, and they're going to continue to get paid. This one here, like the example, it sounds like it is obviously it's helpful to the workers that were subjected to that. If that is the case, it's a large cost to employers in some cases. When you read it the way it is, often I don't believe this happens. I think often that there is alternate work and the workers are reassigned to it. It's not the type of thing where people are sitting around getting paid and not working, and the employer can keep the people busy enough while they're trying to remedy a situation is probably 95% of the time. Every once in a while, there is a longer stop work order that has affected the operation where they can't find work and they can apply to the director, but it doesn't happen too often.
Hey, Marty, we got a few questions.
Okay.
First question is, if the stop work order is issued to an employer due to an employee disregarding policy and or procedure, the employer still has to pay them?
Yeah, so an officer can issue an order to an employee, right? Like an employee can be held accountable under the Act and regulations. And these are the types of things that we consider when we're issuing the orders of who they're being issued to. Typically, when we find that workers are working in a manner that is illegal and unsafe, 99% of the time the management or supervision is there with them and they know about it. Right? So the employers have to provide a safe workplace and they need to provide supervision to those workers. And the duty of the supervisor is to ensure that they're supervising the workers and the workers are wearing the equipment and the devices and the PPE, the guards, they are following the act and the regulation. That's under the act, that's the duties of a supervisor in short. A worker also has a duty to ensure that they are wearing the PPE and they're following the procedures and whatnot. So if an employer was to, if we gave an order to an employer and they were to, they could possibly appeal that order and say, you know, I've trained this worker. I told this worker what to do. I trained this worker what to do. I watched them, the worker do it to prove that they know how to do it. I have supervisors that I can show you discipline records to prove that my supervisors have held workers accountable when they are not following the rules. Like often we'll, you know, if we look at an employee's discipline file or a coaching file or something like that, often on there is things like they have poor quality or they have a poor attitude or there's theft of time, they're late, they're leaving early and all that. Not very often do we see that someone is being corrected for unsafe behaviors. But if the employer was able to demonstrate to us that, hey, I have the systems in place and I have the supervision, the supervisor supervises, and here is documentation proving that we've held workers accountable in the past and this worker is 100% accountable for this, then we could easily look at that and possibly reissue an order to a worker. The fact is that most cases that's not the case. Most cases that all the systems leading up to it have failed first. Often there's supervisors or ownership right on site with them, and everyone was fine with the activities going on until we showed up. So does that answer your question?
It does. Thank you.
Okay.
And then the second question was, does a stop work order for, say, roofing halt all roofing practices of the company regardless of number of sites?
No. So provincial wide, yes, it would. But if it's ABC, I try and use generic names. I apologize. I don't want to ever use a company's name. If it's ABC Roofing and they have 15 sites going on in Winnipeg and we pull up to a location at 123 Main Street and we see workers are working at a heights not tied off, a stop work order is likely just to be issued to that site. So it'll say the company ABC Roofing, worksite location 123 Main Street, and then a stop work order has been issued to 123 Main Street from working at height. This employer is to cease and not permit activities of working at height until this has been remedied. So there would be like a stop work order and improvement order likely in that situation. And then when the employer would demonstrate how they're going to ensure that this situation is going to be remedied and it's going to be remedied going forward, then that stop work order or improvement order would likely be lifted for that site. It wouldn't affect the other sites. But in the other example we went through, if I go back a couple on this page here, provincial wide. So if we had caught that roofing company 2-3 times in a short period of window at different sites, different crews, and we felt that this is more of a systemic issue. This is a problem throughout the culture of this company, then all sites might be stopped. But the example I just used your question was about, I believe, about stop work orders at an individual site. So it would be for those activities at that worksite location.
Okay, thank you, Marty. Just to build on that same question, the question continues, says, can the stopped workers be reassigned to the same task on a different site?
That's a really good question. I would say they could, but if you're doing it in the similar manner, like it's not going to go well for the company, right? So we have a system here, a case management system, and I can go back to orders we wrote in the mid-90s. So if ABC Roofing or Excavation or pick your name has been caught doing work that's not in compliance with the Act and regulation, and they've been caught several times over the years, and our case management system is going to see every one of it. All the emails back and forth, all the phone calls, everything is going to be in there. And God forbid that ABC Roofing or Excavation has an incident where we come out and do an investigation and we find it's anywhere remotely near the issues we've dealt with in the past. Picture our case. Like we've prosecuted in the last 6 years or so, don't quote me on this, but it's right in around there, about 60, 80 companies. So we do that lots each year. So if this company has, And I think that's one of the things with stop work orders and improvement orders is sometimes, often, there is no cost to them at all as far as a monetary fine. There's a cost with moving into compliance, and there can be a cost to the labor slowdown or stoppage, like anchor cost. But the actual cost to us, it's free most of the time. So I think people think that it's that they're almost okay to continue going the path they're going. But we issued 25 administrative penalties last year. And like I said, over the last, 5-6 years, there's 60-80 prosecutions. So picture our case if it was to go across the street to justice, right? Here's ABC Roofing. We had a worker fall. They're working on a first or second story building. They weren't tied off. Worker was fatally injured or sustained X injuries. By the way, Crown, here is their history over the last 5 years. And it's just, stop work order improvement orders. It's a slam dunk case against the employer. And if we think that the company is, so there's non-compliant, there's inspections we do where we truly believe that the employer didn't know the laws exist, but that's not a defense. They didn't know the laws exist, and they're fully open to what do I need to do to move into compliance, and we'll give them some compliance tools like guidelines or resource material, or put them to one of the IBSPs like CSAM or whatnot if they're not already aligned or using those services, and they'll still get orders and stop work orders, but we understand that it's not necessarily on purpose. Then there's other employers that it's the same crews. We write down the supervisor on site. Lots of times we'll write down the workers on site, and we'll see, okay, here we go again. It's the exact same crew. We gave you an administrative penalty 2 months ago. We issued a stop work order at that time, and you told us that this is what you're going to do to ensure that the supervisor has systems in place, which includes, or the employer has systems in place, which includes supervisors that are going to supervise. Their workers are all trained and provided with the equipment and whatnot to exceed. So on paper, you told us we know better and we won't do this again. And here we are again, right? So it's kind of the long way around the answer, but in short, unless the stop work order prevented someone from moving to another site, and if people's names were called out, the stop work orders applied to that site for that employer. We've had stop work orders on issued to worksite locations where the employer they had to get that roof covered or they had to get the work done, and they've asked us, can we bring in this company to continue to do the work, and we've let them do that. They've had to sub it out to get a different company to do it in order for us to let that roof get covered. But yeah, there is some workarounds a little bit, but at the end of the day, we're trying to just remedy that situation.
Thanks, Marty.
Okay. So the person, so remember, a person can be employer. So the person against whom an improvement order is made only achieve compliance with an order when the officer determines that the compliance has been achieved. So how do we do that? So you may say to the officer, let's say it was an excavation, we are going to ensure that, like lots of times for excavations, there isn't a permit or the serial number. Lots of times we're told that it's going to be V'd out, and it isn't. Well, it's not 45 degrees V'd out. It's like a sloppy 75% V'd out or 75-degree V out. So or I guess you'd say the other way, 25% or 25 degree. So it's dangerous. So we'll issue the stop work order for the excavation. So the employer is going to tell us what they're going to do to remedy this situation. So they're going to write the officer a report of compliance saying, this is how we propose to continue to do this safely. And the officer is going to review what the employer has committed to. And if they're satisfied with that, they will lift the stop work order, or they'll comply with the improvement order and whatnot. And at which time it is then complied. But what happens sometimes where people get themselves in trouble is with a stop work order or something, they think that they're doing what meets compliance, and they go ahead and they start working. So let's say that stop work order hasn't been lifted yet, but the employer is going to make sure all the workers have their fall protection on, and they go ahead and finish off the roof. Companies have literally been prosecuted for that. That's working against the stop work order because they felt that they were in line with the legislation now, and they were okay to continue working when compliance hasn't been achieved yet. So you only get compliance from an officer. You'll get a reinspection report, or a stop work order will be lifted or discontinued, but you'll get a report saying you are now okay to continue with what you had told us you would do. Make sense? Oh yeah, I'm getting nervous here. So last year, like spoiler here, I said this a while ago, last year, workplace safety and health conducted over, sorry, the reason why I said I'm getting nervous, we're getting near the end and we have 15 minutes left. So last year, workplace safety and health conducted over 5,700 initial inspections and issued over 12,000 improvement orders. So those inspections are first-time inspections. That doesn't account for re-inspections. These are only, like with re-inspection, that number could easily be 12,000. We don't count those. This is just an initial inspection. The reason why we don't count them is we might come and do an inspection at, say, a manufacturing outfit, and they might get 12 orders. And different orders have different compliance dates. So we might have to re-inspect that employer 3-4 times before everything is eventually complied. There was a time about 10 years ago where those used to be counted, and it would say, you know, workplace conducted 13,000 inspections last year, whatever the number was. But there was often confusion with that. So we just started about 10 years ago, started counting only the initial inspection that led to the re-inspection. So last year was 5,700 initial first-time inspections. Now that might be the same employer multiple times in some cases, but each one's a new inspection with over 12,000 orders. So because of this, if you believe that you have received an order, one of those 12,000 orders, and it was issued to you in error, or maybe let's say an officer came to your site and was dealing with one of your officers or one of your supervisors, and the worker was wearing a respirator for the work that they're doing, and let's say it looked like it was like a legit respirator, but let's say the officer asked your supervisor, were your workers fit tested? And the supervisor said they weren't. And you got an improvement order to ensure the workers are fit tested. And you're the employer and you realize at this point that your supervisor gave wrong information. You could appeal that order and say, you know, our supervisor didn't realize that these workers had all been fit tested. They have been. Here is the fit testing that happened to all those workers on site that were at that worksite location, and we want to appeal this order. And that order could easily be overturned in that situation because the workers were fit tested. So yeah, so we probably get, I don't know, maybe 50 appeals annually. Most of those appeals are for reprisals, and I'd say around 20% of them are overturned. So the decision an officer made into the reprisal was appealed and overturned. So for those of you that don't know, a reprisal is when someone has raised a safety concern, exercised a right or a duty that is given to them under the Act. It might even be they called workplace safety and health, and the employer found out that they called workplace safety and health, and they've had a loss of pay or benefit. They've had their overtime has been cut, their work location's been changed, something negative has come upon them in a retaliatory manner for raising that safety concern or exercising a right or a duty. And the employer put a punitive measure against them, in short. And they came to us, and the worker made us aware of this allegation, and in which case we go to the employer and we start our investigation. But it's the employer's duty to prove that you didn't terminate, lay off, suspend, whatever you did to this worker, you didn't do it because you're being retaliatory. So at that point, it's up to the employer to say, well, no, we did it because we caught them stealing earlier that day or something. They would have to prove to us. And then at which case the officer is going to make a decision on, do they uphold the or do they support the worker, or do they support the employer? Sorry, guys, my mind's a little bit fried today. I just got over a flu a few weeks ago, and I got another one again, so I'm a little bit disoriented. So I apologize if my words are jumping all over a little bit. If a worker has had a reprisal against them, the employer, the officer can do a few things for the worker against the employer. The officer can write an order to the employer, ordering the employer to make the reprisal stop. Depending how long the worker was without work, the officer can issue quantum, which they would have a calculation of based on this worker's knowledge and experience and expertise and whatnot. How long would someone like them be out of work? Let's say it was 2 months, 3 months. They would order the employer to pay the worker those wages. They could. That's one of the things they could do also. They can reinstate the worker. If they feel it's not going to be a toxic relationship, they can tell the employer, you have to pay the worker these wages, you have to remove any discipline from their file, and you're reinstating them, and make reprisal stops. There's 4 tools that the officer has there that they can implement. They can implement all of them, and they have. So we get quite a few of those a year. Lots of men in the field. So it's anyone that has had an order or decision that they disagree with, they can appeal it to the director. Any hands up?
Question here.
Okay.
Regulations are referenced on an order form. If the company cannot determine, meaning find in written legislation, how the observations violate the regulations, how can we get clarification on this? Is that an appeal, or is there a step before this?
No, so like I would reach out to the officer that issued the order and just say, like, I'm not clear of what is non-compliance. Therefore, I'm not clear on what compliance looks like. And the officer can walk you through that. If you found that that you still didn't know, like, you could technically appeal that, although we would ask you the reason for the appeal. And I think it'd be more that there might be more of like an officer complaint, that I've been issued an order and I've asked for clarity on what I've done wrong, and it's not clear in regulation what I need to do to remedy this, nor what I've done wrong. And the officer's not clear, I'd call the manager and see if you can get some clarity on that one. Now, if you felt that once it's explained to you that, yeah, that isn't me at all here, that's not at all what we're doing, I disagree, that's what you're seeing, then 100% appeal that. But the first thing I do is try and find out is what I did wrong and how do I make this right. And I would really, really try and understand that section of the legislation. So let's say you had scaffolding that was erected and it wasn't correct. Let's say your mid rails were missing and you didn't know you needed mid rails. Let's say you're not 100% sure what the workplace regulation says on that. I wouldn't just, if I was an employer doing this, I wouldn't just fix the mid rail. I would totally understand what the regulation says, and there's guidelines and guides material on this, on what good scaffolding looks like. Because if you get caught again doing something wrong with scaffolding, but it's not mid rails, it's something similar but different, now you're kind of getting to that repeat offense type thing. So you don't get yourself in a situation where it's like, what do I need to do only to fix this? I would say, like, what did you find? And then start researching what good looks like. Because I have seen that happen before. I have seen employers fix only what was the issue, and it gets rectified on that job site. Right before this meeting, like 2 minutes leading up to it, I'm reviewing that exact same thing. I'm reviewing a company that is in line right now. There's a recommendation that they get an administrative penalty. It's $2,500, and they've got this order, the same order, slightly different, a couple months back, and it's kind of like, here we go again with the same employer, right? They're putting their workers at risk, and I think what the employer needs is training on what good scaffolding looks like, to be honest. Because I think they're only doing what the officer tells them to do, and then they move on again. And the next site is going to be something different, and someone's going to get hurt. So,
Okay.
That answer your question?
So Marty, just the comment in response to that by this individual was that historically the officers have told us to, quotations, look it up, zero help. So I think you have given some insight onto that, though.
Yeah, like, so if you say, what order did I get and what did I do wrong, and they tell you to look it up, I would ask for some clarity on that one, right? And if you don't get clarity, then maybe call and ask for their supervisor, right? But if it is a scaffolding that is an absolute nightmare, the act actually talks about this. They don't have to walk you through it. The officer can say, you need to go get training and fix all this stuff, or whatever guidance they give you, but they don't have to walk you through it and kind of hold hands to achieve compliance. If it's a smaller issue and easier to explain, sure, but keep in mind, it's the employer's responsibility to have the systems in place, the supervisors, and the knowledge to ensure that the workers can do this work safely. That knowledge, the Act says that knowledge and system all has to be there. So if it is quite bad, and there's many things, you probably won't be walked through all of it. You might be told to go get the training or to go get the guideline, et cetera, to fix this issue, because it's larger than a safety and health officer, and they need to, we need them to go on to the next worksite location and continue on with their inspections. Now the intent is that they are helpful, but like I said, they're not going to be your safety coordinator and spend hours with you walking you through this. It might not very well be what you want to hear, but it's just the facts of it. The intent is employers have all these systems in place, and in being a member of CSAM, the information would be available, right?
Great. Thank you, Marty.
Any follow-ups to that?
No.
Okay. The top orders for construction. We might want to write this down here. Fall protection is the #1 order. General duties is this could be failure to report a serious incident. This could be mitigating or the hierarchy of controls. It can be a few things under part 2 for general duties. Personal protective equipment is another top one. Excavations, machine tools and robots, and asbestos. So those are the top 6 things we are likely to see when we're doing inspections in construction. If those apply to you, maybe take a note of that, and when you get back to your workplace, ensure that stuff's in place. Respirators, if you're working with something that needs a respirator, no facial hair, it's worn properly, it's stored properly. It's in a Ziploc bag at the end of the shift, or workers aren't walking around with it flopping off their neck. PPE, it's the right stuff. It is, what else? Hard hats when they're required. Construction is pretty much all the time. Make sure they have it. Flag person, you'll see flag people people flagging that they're not flaggers. They don't have the proper, they're not licensed or certified. They don't have the proper PPE, the paddles, they have a phone or whatnot. So these are the big things we see. Obviously construction goes on all year round in Manitoba, but we're about to see it ramp up. And these are things that we're likely to come across. Because construction is out in the open, it's not behind walls. We get lots of phone calls. We get thousands of phone calls a year from people calling in concerns they see on construction sites and whatnot. So do your best to go ahead. Sorry.
Is regarding asbestos. So how does workplace safety and health determine an ACM? Will ACM testing be completed?
So that's up to the employer. So the employer has to do an assessment to determine if there's ACM in the workplace. Okay. Anything, I can't remember the exact number. I think it's like containing more than 1% is considered to be asbestos. So if they haven't, there's things that are ACM, we just consider them to be asbestos. If it hasn't been determined, like maybe insulation so what we do is we look at the age of the structure. If it's built prior to 1990, we consider like it's likely to have asbestos in it, but it's up to the employer. I'm not a hygienist, so I'm not, this is definitely not my comfort zone, asbestos, but the employer has to ensure that the workers aren't going to be exposed to asbestos. So they'd have an inventory of all the asbestos in the workplace. So they typically are going to be hiring someone to come out there, and they're going to be testing the drywall compound, the tiles, the exterior shingles on the structure, the stucco, the insulation, the pipe wrap, the boilers, the things where we typically see asbestos in it. They're going to send that away. They're going to get someone in there and take those samples and send them away to a laboratory who's going to tell them whether it has asbestos or not in it. If it does have asbestos in it, the next thing that's going to happen is the employer is going to develop a plan for that, how they're going to ensure workers or people aren't exposed to asbestos that they're disturbing. They have to notify the Workplace Safety and Health branch at least 48 hours prior to disturbing asbestos, at which case, numerous questions are going to be asked of you to ensure workers aren't put at risk. Each year in Manitoba, or each week in Winnipeg, the city of Winnipeg sends us a list of all their permits. We vet those permits and we look for the permits that are likely to have asbestos disturbed. And we reach out to those building owners or whoever's doing the work, and we ask them for a copy of their their assessment and their inventory or their control plan. And we issue stop work orders very frequently, just from this alone. Keeping in mind, asbestos is the #1 killer for occupations, occupational killer in North America. So lots of people lose their lives because of it. And you need to be really, really careful working around it. You need to be trained expertise.
Great, thank you, Marty. A follow-up to that is, would a consultant be required to produce that report?
Yeah, we want to see somebody that's competent. So someone that's competent in identifying and reviewing. Like, we've had reports sent to us from consultants that were given to the employer, and the employer said there was no asbestos in here because there was less than 5%. It's like, that is full-on raging asbestos. Your building has asbestos. Here's your stop work order, because they were going to work through it thinking it didn't have asbestos, and their consultant report, because the employer didn't even know what they were reading. So yes, we want to make sure that the person identifying is competent and they know what they're dealing with. And then we want to make sure they have a plan to deal with it properly, to remove it, to get rid of it. It's got to be disposed of properly too. It just can't be put in a bin. It's got to be, so it's going to be put in the bin. It's going to be like put in big, thick plastic bags, basically, and then taken to the dump. When they get to the dump, they're going to be telling them this is hazardous material, it's asbestos, and it's going to be labeled in the ground for environmental reasons, to make sure it's never just dug in that spot and disturbed and someone digs into asbestos unknowingly. So there's a full process to make sure it's disposed of properly. And we want to make sure all that stuff is happening. Now, do people, get away with them occasionally? I'm sure, but we don't know about it. Just like I'm sure there's workers working out there at heights right now, nights hat off, that we don't know about. But it's, if you know about it, call it in and we'll go deal with it. We do this all day long.
Oh, another question coming up here is, can workplace safety and health mandate that a report be completed by the employer if none has been done based on the risk and building age?
If we see a building that is built prior to 1990, and there is renos or demo or something like that going on, and yeah, we are 100% going to say we want to see an assessment or an inventory of asbestos on the structure to ensure it doesn't contain asbestos. So we're looking for, and we will often go out there and follow up. We've had buildings where they came back saying there's no asbestos, and several times we have gone and done our own asbestos assessment and determined that there is actually asbestos in there and workers would have been at risk had it been disturbed. So yeah, we do that. If the formula checks, like the material is in there that likely is to be asbestos containing, and the structure is older than 1990, then we're gonna be asking for an assessment. Yes.
Good. Thank you, Marty.
Yeah, no problem. We're good?
We're good.
Okay, there you go. 105, not too bad. Some
Excellent.
good questions. I appreciate getting them. I wish it was in person. I like to see the people I'm talking to and whatnot. But is there anything else before we take off, folks, that there's something you might have or something you're wondering, or maybe it's workplace safety and health, but it's just not quite what we discussed today and it's something different you've been wondering?
There's nothing else that's coming up.
Okay.
I'll get you just briefly now, Marty, just to stop your sharing.
Okay, there you go.
Excellent. And I will just want to say thank you to everyone who joined in today, and thank you to Marty. I just wanted to make everyone aware that we do have some stuff coming up for the rest of the week. On your screen, you'll see briefly, if I can pop it in here, 3 sessions we had this week. Today's session with Marty. We have another session tomorrow on cultural competence, and then we've got psychological injuries on Thursday. So if you haven't already registered to attend, please use that QR code on the screen there. You can register and you will receive a link shortly to join in on those webinars. So thanks again to everyone that has attended today. And thank you, Marty, and for all those questions that came in and your responses, Marty, much appreciated. And we will if not see you tomorrow, then we'll see you soon. Have a great day, everyone.
Thanks for having me, folks. Take care.
Bye-bye.
Bye.